obligations under Rule 14 in this matter, Your Honor.
But that doesn't really answer my question.
Considering everything that we saw in the Karen Reed case, isn't it nice to kind of see a judge giving the Commonwealth a hard time?
It's the Commonwealth's obligation to get materials from the federal government.
In the aftermath of the Karen Reed case, Massachusetts prosecutors are between a rock and a hard place in their attempts to prosecute Brian Walsh. All right, maybe it gets a little bit complicated, but we are going to explain to you exactly what is happening in the Brian Walsh case. I'm Attorney Andrew Myers. This is About the Law. Joining me is Orange County, California Attorney Yolie Medina. Yolie, how are you?
I'm fine. How are you?
I'm good. I have a big announcement to make later on in this episode, but let's jump right into the Brian Walsh case. Brian Walsh is the suspect who is being held on suspicions that he emmed his wife New Year's Eve 2022-2023, and that he dismembered her. The entire body has never been found, but based on a whole series of really, inculpatory searches that he made, doesn't look good for him. But now the Commonwealth is having some problems with some materials that they got from the federal government for the Karen Reed case. Are you following this, Yolie?
I'm following it. Proctor. It's about Proctor.
It's a little bit complicated, but yeah, that's it. That's it. Because Michael Proctor did what he did in the Karen Reed case and ended up being dishonorably discharged for a couple of things, unbecoming conduct in the texts that he had sent regarding Karen Reed, but also drinking on the job. Now the defense attorneys for Brian Walsh want to be able to use the federal materials that had been provided during the Reed case. But the prosecutors in the Brian Walsh case are saying, no, we signed a federal protective order that orders that after the Karen Reed case, we never disclose this stuff. We return this stuff to the federal government, and under penalty of contempt or otherwise, we may not ever give anybody these materials. So there was a hearing. There have been a couple of hearings on this matter, and the judge said, well, get in contact with the federal government and find out, if they won't give you those materials. Well, here's what the federal government said. You know how the federal government is. I mean, you never get a yes or a no. You get it could be this or it could be that. Here is a piece of correspondence that comes from the U.S. Justice Department in Boston, the District of Massachusetts, U.S. Attorney Leah Foley, to Lisa Beatty of the Norfolk County District Attorney's Office in Canton, Mass. Request concerning producing confidential materials from Commonwealth versus Karen Reed in other matters concerning former state trooper Michael Proctor. So this is the federal government telling the Massachusetts state government, essentially, by way of the Norfolk County District Attorney, here's what we're going to do. Dear First Assistant Beatty, as you're aware, in response to a joint TUI request by the parties to Commonwealth in the Reed case, my office produced certain federal records, the confidential materials, to the parties in that matter. The confidential materials are subject to a protective order issued by the U.S. District Court for the District of Massachusetts, and that order requires the party to destroy those records upon completion of the Reed matter. As you're also aware, the trials in that matter included testimony regarding communications about the defendant, Karen Reed, by now former Massachusetts State Trooper Michael Proctor. You've been advised, my office, that the Norfolk County District Attorney's Office, and we're going to call them the NCDAO from now on, is prosecuting other cases Proctor investigated. We're going to call those other matters because the protective order only permits the parties to use the confidential materials in the Reed matter, And you believe that the NCAO may have discovery obligations under state law to produce some of the confidential materials to the other matters, you have asked my office to seek an amendment to the protective order to allow, one, the district attorney to produce from the confidential materials any statements by Proctor to the defendants and their counsel in the other matters, and two, assistant district attorneys prosecuting the other matters to sign the protective order, review the entirety of the confidential materials, and produce any other of the confidential materials to the defendants and their counsel in those other matters that the district attorney would be required to produce under the district attorney's criminal discovery obligations. And that would be called Rule 14 in Massachusetts.
All right. So the next paragraph says, pursuant to 28 CFR section 1621C, which permits the United States to produce federal records to any law enforcement agency in the absence of a TUI request, I am producing to the district attorney all of the Proctor communications previously produced as part of the confidential materials. Given these records are produced pursuant to section 1621C, they are not subject to the protective order, and the district attorney can use them as appropriate in other matters. As you will see, most of these statements already are reflected in the Reed trial record, and none appear to concern defendants in other matters. My office is nevertheless producing them to facilitate the district attorney's prosecution of other matters.
So they're starting out this letter looking like the good guy. Hey, of course, we're going to let you do it. We're not going to make you do a TUI request. And under a different section of federal law, we're going to be the good guys and let you have all this material. But wait, there's more. I hate when people say that. To the extent that the confidential materials contain federal grand jury testimony by Proctor, and without confirming or denying that such testimony exists or was in the confidential materials, my office would be prohibited by federal law from disclosing that testimony for use in the other matters, absent a court order. Wait a minute, we did hear about grand jury testimony in the Reed trials, didn't we? So, yep. Moreover, my office would not have a sufficient basis to move the U.S. District Court for a disclosure order under the circumstances. So we're not going to give it to you without a court order, and we're not going to ask for a court order. My office's investigation pertained to the circumstances underlying the Reed matter, and therefore any grand jury testimony by Proctor in the confidential materials would not have addressed the other matters. Yeah, but you're missing the point. The point is that, if he engaged in conduct unbecoming to, a proper and fair investigation, that's highly relevant.
It is.
That was me. But I interjected that into the letter.
Yeah, but it is relevant, I think. I mean, yeah.
Well, she's getting up on her high heels and saying, no, I can't see any reason we should give you this. Furthermore, assuming for argument's sake that the confidential materials contained in Proctor's grand jury testimony, he testified at the first trial in the Reed matter and would have been subject to impeachment with that grand jury testimony, the trial testimony from the Reed matter, therefore, would be more than a sufficient alternative to assess Proctor's basis. Not really, because they may not have used it all. They didn't even put Proctor on the stand in the second trial.
That's true.
Finally, yeah, they didn't even bring him in, which now, in retrospect, might be considered a mistake. I don't know. I'm not in their seat, and Hank Brennan will not talk to me anymore. I've invited him. I've invited him twice, and he's. I knew it was him when the phone didn't ring. Finally, any grand jury testimony by Proctor would be cumulative of other sources of evidence of Proctor's bias as to Ms. Reed already available to the defendants in the other matters, including the extensive trial record in the Reed matter, the Massachusetts State Police disciplinary proceedings against Proctor, and the statements produced with this letter.
Similarly, my office will not seek a further amendment of the protective order to allow assistant district attorneys prosecuting the other matters to review the entirety of the confidential materials for potentially discoverable information. Wow. There is no reason why the non-proctor records within the confidential materials would be relevant to other matters given the scope of my office's investigation. As mentioned previously, my office's investigation focused on the circumstances underlying the Reed matter, and the confidential materials included only those materials from that investigation that were highly relevant to that matter. We accordingly have no basis to believe that there is anything else relevant to the other matters in the confidential materials. Further supporting this position, besides Proctor's statements, the district attorney and defense counsel in the other matters have not identified any documents or categories of documents that might be included in the confidential materials that are relevant to the other matters, despite many of the confidential materials being referenced during the public proceedings in the Reed matter. Nor would it be appropriate for my office, the district attorney, or any defendant to comb through the confidential materials on the mere possibility that such relevant information might exist.
Wait, what? She's saying you can't have it because you can't identify any specific document. Well, we don't know what's in there. So, it's okay under most rules of discovery to ask for categories of documents. So, A, we're not going to let you have this stuff because you haven't identified any specific documents. But B, we're not even going to let you take a look so that you can identify specific documents. So I think that's what they call circular logic. I'm not sure.
Yeah.
My office appreciates the concerns of, my office, it's always dangerous when somebody starts out a letter that's going down this way with, my office appreciates the concerns of the district attorney, defense counsel, and the state judges presiding over the other matters. My office is keenly aware of the seriousness of the charges in some of the other matters and wishes to see that justice is done. Yeah, right. This response, I believe, does that while balancing the U.S. interests and compliance with federal law.
Given this response and the fact that the Reed matter has concluded, the United States requests that the district attorney comply with the protective order and destroy its copies of the confidential materials according to the deadline set in the U.S. District Court's July 21st, 2025 order. I nevertheless want to make 2 points that I hope will guide the district attorney's decisions about future action. First, given that the federal court's protective order sets forth strict parameters for dissemination of the confidential materials and noncompliance with that order affects a federal interest, the United States is obligated to ensure compliance with the protective order. Should any Massachusetts court authorize the unsealing of the confidential materials in a manner that is inconsistent with the protective order, the United States may need to take appropriate action to ensure that the protective order, as a federal court order, and the United States interests are adequately enforced, which could include removal to federal court of any adverse ruling pursuant to 28 U.S.C. Section 1442. To be sure, the United States has no interest in that course of action, particularly given that it believes it has provided any material from the confidential materials that could be relevant to the other matters, as permitted by law. And the parties in the other matters have more than ample publicly available material concerning Proctor's bias as to Ms. Reed.
Okay, so here's the Cliff's Notes version of that. We're the federal government. We're bigger than you. Commonwealth of Massachusetts, you can go screw. And if you do something in your little teeny tiny little courts down in Massachusetts, we're gonna crush you like an ant. I mean, talk about using your superior, as you see it, position as though you're the big bully and the states can go to hell. I don't know. That's just me, people. That's just me. That's not any of the parties in this case. We're almost done with this letter, and then we're going to go to court and hear what's being said in court and why this is so important. This is a very important issue under the concept of federalism, despite how it sounds. The states have all powers that weren't reserved to the federal government in its, capacity in the Constitution. So Methinks thou protest too much is my take on this. Second, in the United States' view, it would be inappropriate for the district attorney or defense counsel in the other matters to seek intervention in the U.S. district court matter and move to amend the protective order. Not only is there no basis for either party to intervene in that federal court matter, but any such motion should be dismissed because the parties have failed to comply with the so-called TUI. Wait a minute. I thought you just said earlier in this letter that, oh, you don't have to comply with TUI. We'll be the good guy, and under a whole different section of federal law, we'll just give you this stuff. But now they turn around and say, oh, you haven't complied with TUI. These regulations, the predecessor of which was upheld by the Supreme Court in U.S. TUI v. Reagan, 340 U.S. 462, 468, 1951, and I expect all of our viewers to go look that up, require parties seeking federal records to meet certain requirements, including submitting a written demand identifying the specific material. Well, how can they identify the specific material if you won't show it to them?
Yeah, it's kind of circular.
This is a lot of hot air and steam coming out of the U.S. Attorney in Boston.
Relevance, but not only identifying the specific material, but its relevance.
They've been doing a lot of construction work in that part of town, and sometimes you actually see steam flying up from the sidewalks. And I think that's what's happening here. We have a lot of steam flying out of the federal office here. To the extent certain NCDAO assistant district attorneys and defense counsel have submitted TUI requests seeking federal records concerning the Reed matter for use in the other matters, the United States has or will consider them in due course. To the extent that a party submitting such a TUI request is dissatisfied with the U.S. response, the only legally appropriate avenue for challenging the United States decision is to file an action in federal court under the Administrative Procedure Act and not seek to amend the protective order. Quite a letter, really quite a letter from the federal government, just, exercising their alleged superior weight in this matter. And they don't want to, I think this could have been, although I guess not, because I know that there was a phone call. I know that there was a phone call between the district attorney's office and the U.S. Department of Justice. And I think this was the result of the phone call. So I was going to say, this should have been resolved in a phone call or a discovery master stepping in, but looks like those were not alternatives. So, it's just a little bit heavy-handed. In my view, I don't know. What's your thought?
The federal government seems to make it hard to get anything from them. It just seems that way in every type of case. In Koberger, they were having trouble. It just seems that getting anything that could potentially help a defendant. That's just my take on it.
So now here's the real problem. It would appear, and I have said many times, that there's no such thing as a slam dunk case. There really isn't. But to the extent that this case, the case of Brian Walsh, whose wife disappeared, and then he was seen on video disposing of large bundles into dumpsters in different towns and locations, and who was seen buying $500 worth of cleaning supplies at Home Depot, and who made, a dozen or more, actually more, crazy searches for things like how to dispose of a body, what does formaldehyde do, and on and on and on and on. It would seem that this is a case that professional prosecutors could put it all together and get a conviction from a jury. I've said before, and I mean it seriously, that all defendants are entitled to a presumption of innocence, and Mr. Walsh, despite everything I just said, despite that evidence, is entitled to that presumption of innocence. But the prosecution does face some problems. They have now overcome a motion to suppress, but on the other hand, there is Michael Proctor. And, obviously the defense wants to play that up as much as possible. And there was a recent court hearing in Norfolk County in the same courtroom in which Karen Reed was acquitted in 2 trials. And here is Larry Tipton, the defense attorney for Mr. Walsh, with Mr. Walsh looking on, really hammering the prosecution.
The Commonwealth has failed to inform this court or any part of it what the exact basis is that they're relying on that says they can't review the documents in their possession and custody for Rule 14 information as defined by Rule 14.
So they're really taking advantage of this. Again, the Commonwealth has this conundrum that they are aware of these materials. They've seen these materials. Some of the same attorneys that prosecuted Karen Reed are on the prosecution for Brian Walsh. And they're under this federal court order, do not use or release these materials. But on the other hand, Brady and Rule 14 in Massachusetts require that all evidence be produced, including and especially exculpatory evidence. So this attorney really went to town on that. How can they not do this? How can they not provide this evidence? And the judge chimed in and really was hammering the assistant district attorney, Tracy Cusick.
We have unique circumstances here. Is it your view that even though these are nominally controlled by the feds, that you don't either possess them or have custody of them?
This was a Zoom hearing, so you see he's not in the room, but you see Brian Walsh there in the right little box.
Your Honor, it is our view that doing what counsel is asking would be violating a federal protective order.
Reviewing the documents would violate a federal protective order?
In conjunction with a different case other than the Reed matter. In this case, we do have the unusual circumstance of someone assigned to the Reed matter is also assigned to this matter. And
so your position is even reviewing the documents, reviewing the documents in this context is not required by Rule 14?
Your Honor, I believe reviewing the documents in this context would be a violation of a federal court
But that's
order.
a different question. The question is, does Rule 14 require you to review these documents?
I don't believe it does, Your Honor, in the current posture of this matter.
I'm supposed to remain unbiased, and I'm trying really hard to remain, fair and unbiased. But considering everything that we saw in the Karen Reed case, isn't it nice to kind of see a judge giving the Commonwealth a hard time, which is what's happening here?
Yes. And I think, and I mean, I don't practice in Massachusetts, but I think that there's a duty to review them at least, because, like you say, if there's Brady material, information like that, it should be produced.
Oh, I agree 100%. They should at least review it.
Yeah.
They're between a rock and a hard place. If they go beyond the scope of the protective order, they could face federal contempt. If they don't look into this, they could face contempt in the state side. So
it's just catch-22.
Yeah, I wouldn't want to be either. It's a tough call. Let us see what our commenters have to say about our coverage the last time around in the Reed-related matters with respect to Turtle Boy. Are you taking the evens or the odds this time?
You take the odds.
Okay. I haven't read enough. I got to read more. Okay, that's fine. So KTD 1988 says, I'm confused on what harm Turtle Boy actually caused anyone. Criticizing somebody and hurting their feelings isn't exactly illegal. I'd have to agree. I don't know.
This is, how come I get the hard names?
You pick the even ones.
Lieber Coates. The federal government should assign a federal task force team to assist Massachusetts U.S. Attorney Leah Foley launch an extensive investigation into all allegations of corruption, cover-ups, and conflicts of interest that seem to be taking place in the Massachusetts legal system.
Seems about time. It does seem about time because, between the Miles King case where discovery wasn't forthcoming for 4 years, where there were 6 subpoenas, the returns of 4.5 of them, I believe, were never produced to anyone, to the prosecutor, Adam Lally, and certainly not to the defense. I don't know. VI Girl 60. Thank you. I apologize for putting these self-serving ones in, but I can't resist. VI Girl 60 says, "Thank you, Andrew, for your commentary on the important issues Aiden's case is exposing. Legacy media refuses to expose that fact. The criminals control Norfolk County." There are some good reporters. Overall, I think VI Girl, you are correct, Amundo, but I think, there are some good reporters that are following stuff. There really are.
Sharon Lubitschek. My God, this is infuriating. And as a citizen of Massachusetts, I am ashamed and embarrassed.
Yeah, I don't think this is unique to Massachusetts. And I have gotten some comments that, this stuff happens in other states. I mean, look, the mayor of Providence, Rhode Island was thrown in jail. The mayor of Chicago was thrown in jail. I don't follow it, but California isn't perfect, is it?
No.
Okay.
No.
Number 1, Bumbling Bee. If DAs were actually punished for things, I promise they would suddenly start sending discovery and not have issues with electronics, etc. Well, that goes to the Aiden Carney case, and it also goes to the Miles King case where discovery has not been forthcoming. And not only that, some of Aiden Carney's episodes, when they were presented to the grand jury, the titles were doctored to make it, show that he had intent. So, it's a good comment. I don't know. It's really a mess. It is kind of embarrassing. It seems that something should be done to watch over the district attorney's office at the very least. Although, if they have been doing what they're doing for so long and never been caught, why wouldn't they continue to do it? I mean, in a previous episode where we covered Adam Lally on the stand being questioned, there were subpoenas that were issued and you knew about them. Did you ever follow up on them? Well, I thought I'd wait until they got back to me. Well, what's your policy? Well, we don't really have a policy. It's just, if you have a job where you're just like kind of, sweeping the floor, and I'm not disparaging people that sweep the floor, but I guess it's okay to do it when you get around to it. But, I don't know. Do you have any closing thoughts for us on this?
No, just that this whole discovery thing is getting old. We hear it in a lot of the high profile cases, and it's just, it gets old. It's like, come on, people.
It does get old, but for a guy like Miles King that was accused of M in Boston, in the Boston area, I should say, 4.5 years ago, and for his attorney to still not have the discovery, it's not just us sitting around on a podcast trying to find something to talk about. It's way more important than that. It rises to constitutional levels. And no, we're not just sitting here, saying, "Oh, the poor defense attorneys." No, anywhere you live, I don't care if you live in the Commonwealth of Massachusetts or Washington D.C. or anywhere. Don't you want prosecutors to be on top of stuff?
They need to get it together. You hear this that they're not producing disguise. Come on, why can't you just get it together?
Yeah, my point was. Anywhere you live, if people are accused of crimes, don't you want to give them a speedy trial? And don't you want prosecutors to have it all together and know what their obligations are with regard to Brady and the Constitution and Rule 14 in Massachusetts? Don't you want prosecutors to be able to do their jobs and do it competently? And that, by the way, was a rhetorical question. I think the answer has to be yes.
Yeah, so that criminals don't get off on technicalities.
So anyhow,
the last more crimes.
You know me. The last thing I always like to mention is, and we started this with the Karen Reed episode, and in the last week we have gotten a new country. This mighty little channel now has heard from 79 different countries have given us comments and questions, and so we're still counting. I was going to retire this slide after the Karen Reed trial, but I changed my mind. That's my prerogative. And so if you're in a country, look, we have so many of them that they're kind of falling off the slide. We're going to have to redo this. If you're in a country that is not listed on this list, please take a look and let us know. Let us know, because someday we're going to run out of countries, but we're not there yet. I think we're about halfway there. But anyhow. So the last thing that I do want to say in this episode is that, we have a surprise announcement. Those of you who have been watching this channel for a while have been asking questions down in the comment section. We're going to answer those questions, and we're going to do something we don't normally do. We're going to do a live. Hopefully, we're going to be doing this every Tuesday night from now on. We're going to do a live. I haven't really been excited about doing lives, but I have somebody that's going to help me, somebody that will answer some questions that you've had down in the comment section. So join us this coming Tuesday at 5 o'clock Eastern time. I guess that's 2 o'clock for you out on the West Coast, right, Yolie?
Mm-hmm. Yeah.
So we'll answer your questions in the final thing. I always put you in. I love putting you on the spot. You must hate me.
I'll try to make it to the 2 o'clock live on Tuesday.
Oh, you don't have to do that. You can't. You're more than welcome. You're more than welcome. But I was going to put you on the spot on if people have watched this episode all the way through to the end, what emoji should they leave us?
Paperwork.
A pile of papers. There are papers. I know a couple of weeks ago we asked for letters. We asked for envelopes. But so, papers. Because there's a lot of paper in the federal building in Boston. Oh, anyhow, I didn't say that. Okay.
I don't know what else to say.
All right, Yolie, thank you again for joining me for this episode. I really appreciate it. Right. And to our viewers, thank you very much. Be nice. I always say this at the end. You know, people will make a comment, and I want people to comment. I want to encourage people to go down there and tell us what you think about the things we're talking about and what we can do in future episodes. And I have paid attention to future episodes that people have wanted us to do. I have paid attention, and we're working on a couple of them, but I just want people to be nice in the comments. If somebody says something that you don't agree with, that's fine. Instead of saying, they're a this or they're a that, because once you call somebody name, I stop reading it. Start your own string and say, I think this, and here's why I think that, and give us some facts or give us some law underlying what you think. I really don't like it when you disparage somebody who's one of my fine listeners from one of 79 countries. I really don't like it when people, call people names. Start your own string and tell us what you think. So be kind. Right, Yolie?
Yep.
Whether you're in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.